and other difficult, sensitive issues, which happen to fall smack dab in the middle of a coronavirus pandemic and also in a presidential election year. There was a bit of a perfect storm here, not to mention today's employees have different tools available to them to express their opinions rapidly and widely. But this is the backdrop of our discussion today, because there are also a number of workplace laws that may protect that speech and conduct. So where does this leave the employer who is trying to push on and get through this? Next slide, please. So even if you're currently unaware of employee discussion of politics and other issues at your workplace, it is likely something that is affecting your workplace, which is why I include these stats here as well. And one in particular really stands out to me, which is that 56% of those who responded to this 2019 SHRM poll said that the discussion of politics in the office has become more common in the past 4 years. And too large of a percentage of those in the American Psychological Association survey indicated that politics had an effect on their workplace productivity and even their employee relationships. So how do we get a hold of this? Next slide, please. The starting point for addressing political behavior in the workplace depends first on whether or not you are a public or a private employer. The next slide. When it comes to political speech and conduct, public employees, all right, are generally protected by state and federal constitutional provisions, including the First Amendment, which guarantees free speech, and the Fourth Amendment, which prohibits unreasonable searches and seizures. The thing to be aware of here is that even for public employees, for those of you who are public employers on this webinar, if the speech is not of public concern, or in other words, as a private citizen and not part of their official job duties, okay, if they're speaking as a private citizen, it is protected. But if they are acting as part of their official job duties, it is not protected. And even if they're able to argue that they are acting or speaking out of public concern as a private citizen, courts are still going to balance factors including whether the speech interferes with the employee's workplace duties, creates a conflict, or undermines the public trust and confidence in that public entity. Next slide. Employees working in the private sector, however, often don't understand that the constitutional First Amendment right of free speech that applies to government employees does not apply to them, right? Employees of private employers are not protected by the First Amendment while at work. This means that when you have an employee come to you and say that he will not wear a mask at work because it is his First Amendment right to refuse to do so, which, by the way, this has actually happened to one of our clients, that employee is wrong about the basis of his right. As an at-will employee, of course, he has the right to refuse to do so, and he can quit his job. But as the employer, you would also likely have the right to not allow him to continue to work unless he complies with the company policy and procedures. But again, we would have to look at whether or not this conduct is protected by federal and state laws. Now, as a side note, if the employee has an employment contract or is subject to a union contract, you are going to have to refer to that contract at issue in addition to these laws that may protect the employee. And the same would go for any public employer as well, as union contracts are very common in that field. But again, if you are dealing with an at-will employee who is not protected by a collective bargaining agreement or another contract, we need to consider the statutory and common law restrictions on the employer's ability to regulate political speech, and activity. Next slide. So, shutting down or curbing political speech in and of itself without being tied to an employment issue in the workplace is not likely going to find protection under the various laws. Next slide, please. After all, and in particular, we're talking about non-discrimination laws here. Obviously, Title VII, there are also the supplemental state statutes that also protect protect against discrimination. Now, under those laws, of course, employers have an obligation to stop certain types of speech and conduct that could create a hostile work environment or subject employees to harassment otherwise based on their protected traits. For example, when you hear the words "you people" or "people like you" and that creeps into the rhetoric, it's probably time to shut the conversation down. So although political affiliation is not a protected class, I think what's really key to understand here is an individual's political stance is highly personal. It's personal because it's often tied to the religious belief, their race, their gender, you name it. And with the current media and politician focus on these topics like racial inequity, immigration, gender pay inequity, it's easy to see how one of your employees' expressed opinions at the workplace can be perceived as hostile or abusive by another employee and then potentially violate workplace discrimination and harassment laws. However, what if someone starts talking about political issues like Me Too harassment and Black Lives Matter and then specifically ties it to his or her current work conditions? That speech may be protected. Next slide, please. Section 7 of the National Labor Relations Act provides that employees have the right to engage in concerted activities, meaning one-on-one employee, right? 2 employees, it's concerted, for the purpose of collective bargaining or other mutual aid or protection. So the National Labor Relations Act protects both union and non-union employees who engage in this sort of concerted activity for mutual aid or protection. And it gets tricky because drawing the lines between that protected concerted activity under the NLRA and unprotected political activity is often a gray line. So, for example, let's say you're a non-union private employer. An employee has been openly discussing her participation in recent protests around the city, which she's been doing on her personal time. The protests have been regarding pay disparity. You have a policy that discourages political activity at work. In fact, when someone repeatedly walked through the workplace with a Make America Great Again flag last year in the office, you disciplined him for violating that policy. Now this other employee has brought her protest to work. She has a T-shirt on that says, you know, insert company name here, "Why do you pay him more than me? Why do you pay him more than me?" She is clearly grieving what she believes to be a pay disparity at her own workplace. She is clearly appealing to her coworkers at the workplace, and some of them join her and put on the same shirt. Now it's concerted. It has gone beyond this general political activity and now is arguably moved into the realm of her trying to seek mutual aid for work terms and conditions. You discipline her for violating the same policy, and her lawyer argues that the activity in the office is protected by the NLRA, and the company's discipline of her was retaliation for exercising her Section 7 rights. Yeah, her lawyer may have a basis for an unfair labor practice charge against the company. But ultimately, this protection under the NLRA is confined to specific topics with a connection to the workplace and the employee's terms and conditions of employment. I can't emphasize that enough. So the NLRA still allows the employers to restrict workplace communications about all other political topics as long as those rules are uniformly enforced. Now, for our public employers, I do want to make sure I make clear here that the NLRA applies to private employers. but the state labor laws often closely parallel and even refer to the decisions on these NLRA issues. So when I discuss the NLRA throughout this presentation, it is likely that there is a parallel within the state public labor laws that apply in your state. Next slide, please. So employees, of course, also still have state protections. I'm just giving you a flavor here on this slide. For time's sake, I'm not going to run through every one. Obviously, each of these have nuances. So for any location you are in, you will need to take a deeper dive in order to find out what restrictions and parameters you're going to need to work within. Next slide. In Illinois, the law that protects employees, there is a law that protects employees from discriminating against employees for their off-duty political activities. Next slide. In Wisconsin, there are protections for employees, including no threats of termination or reduction in pay to influence employees' votes in elections, and no retaliation for refusing to take part in an employer's communications about political issues. That's an interesting one. Notably, Illinois and Wisconsin laws arguably prohibit discrimination and retaliation against employees who use social media platforms to express their political beliefs. In Indiana, next slide. In Indiana, an employer cannot push political agendas in their compensation paperwork. So basically, you can't have hidden or direct messaging within any of the paperwork that's telling your people how they're going to get paid. An employer also otherwise cannot threaten to take adverse action if a certain candidate is or is not elected to office. And then next slide, please. In Missouri, employers cannot prevent employees from engaging in off-duty political activities, such as running for office or being active on a political committee. So in short, there are protections that you need to be aware of and which need to be analyzed before you take action to discipline an employee for certain political conduct or speech. So how do we nip this sort of activity in the bud? How do we set workplace expectations for this? Policies, of course. I know everyone was saying that at the same time, policies. So I'm now going to turn this over to Heather to discuss workplace policies.
Thank you, Bev. That was a lot of great information. And you are correct. You know, that's what employers are going to need to rely on. You should be having, you know, a code of conduct policy that defines how your employees should act on a day-to-day basis. You need to give them the playbook. If they don't get the playbook, they're not going to understand what's expected of them. You know, in most cases, you know, reprimands are going to occur when an employee's conduct interferes with his or her work activities. But if a political debate disrupts the workplace, it can result in a violation of the policy. I can't stress enough how important your workplace policies are in these situations, because you're not going to be disciplining them or reprimanding them based upon because of political speech and things like that. It's going to be because they violated your policy. And that is your best defense as an employer when you're dealing with these situations. So we have another SHRM poll that was taken, and, you know, 67% of the companies do not have a written or unwritten policy on political activities in the workplace. That's a high percentage. You know, 24% of the companies that participated did have a written policy on political activities in the workplace. And of those organizations that did have the policies, over half of them specify what activities are covered. So that's good to see that those companies are out there. And again, they're giving the employees that playbook so that they can know what's expected of them and how to act. And when they don't act within conjunction with that playbook, that's when you can get to reprimand them and explain to them how their behavior is violating of your workplace written policies. Obviously, the biggest one here that's going to come into play when people are talking about politics is your anti-discrimination, your anti-retaliation, your anti-harassment policies. Those you need to make sure, if you haven't dusted them off, you want to dust them off. You know, you're going to enact, if you don't already, having policies regarding discrimination and retaliation. They can be broad enough to prevent political discussions from turning into conflicts between employees. You know, if everyone agreed with the same candidate, we wouldn't be having any conflicts, okay? But when their dialogue turns into violating your anti-discrimination policy, that's what you're relying on. You know, no policy says employees have to like everybody at work, right? We don't have anything that says you have to do that. But we have policies in place that you're expected to work together respectively in the workplace. I mean, that's really when we do our anti-discrimination and harassment training, it's really respect in the workplace and treating each other with courtesy. That's what it is. And you can have a policy that says that. And so when there are differences, you know, and it goes beyond that political speech and it encroaches on this discrimination and harassment, now you're relying on that policy. And you're going to use individual coaching moments with these employees to discuss with them the benefits of diversity and to teach them tolerance and respect. That's what it comes down to when the employees get into these arguments, is that they're not tolerating diversity. Diversity is key. We know that. Diversity is so important. There's studies out there that tell us diversity in the workplace is so important in achieving, you know, company goals. So again, a lot of these employees, previous companies haven't taught them how to treat each other with respect, how to tolerate someone when they have a difference of opinion or something like that. So you're going to have to give them that guidance so that they know how to behave in the workplace. All right, so policies limiting political discussions. You know, while you may not want to ban all political discussions from the workplace, you definitely can establish policies to discourage political conversations that include comments about specific protected classes. Okay, I think, you know, being an anarchy and saying you can't talk about political discussions at all might be a little bit too much. But you can tailor those discussions and give the employees the information and the guidance that you can't be talking about your opinions in that regarding the specific protected classes. Once you start going into race, ethnicity, gender discussions, pregnancy discussions, age discussions, you're now crossing the line and you're getting into that risky behavior that's now going to be violating our anti-discrimination or anti-harassment policy. You know, you want to make sure, like Beverly was mentioning earlier, that you're in compliance with the applicable laws. You're looking at federal, and you're also having to look at which states you're in. And what you can do then is limit what political talk that's going to take place in the workplace, okay? You know, and provide these policies to the employees and make sure, they get these playbooks so they understand. Now, you always want to make sure, and Bev will definitely be on you on top of this, that you have to have a carve-out that information that Bev was giving you on Section 7 rights under the NLRB and the NLRA, that, you know, they're allowed to talk about terms and conditions of employment and things like that. So again, just make sure in your policies you've got that disclaimer in there that you're in no way telling them that they can't have their Section 7 rights. So you always want to have that written disclaimer in there, because as an employer, you don't want to be on the hook with the NLRB for trying to curb those rights that those employees do have. All right, so opinion versus harassment. You know, we always want to talk about that risky behavior when you're crossing that line. And it's crossed when what one person sees as political expression is interpreted as harassment or insults by a colleague. Okay, that's when you have the dispute. That's when you have the problem. That's when it arises. So some examples. You know, one of your employees expresses an opinion about immigration or building a wall along the southern U.S. border. This can easily and obviously move into harassment territory. You know, it depends on the audience. It depends on how it's, you know, the information is presented to the other employee. That's an example. Another one, someone expresses, as Beverly mentioned earlier, an opinion about a coworker's Black Lives Matter mask. Again, it's going to depend on how the information is delivered, the tone that it's delivered in, how, what the information is that it's delivered when they express their opinion. Another example is someone whose politics or religion puts them at odds with legal protections that were recently, as we know, just put in place for the LGBTQ community. And they make a comment with an earshot of someone who is an LGBTQ coworker or a parent of an LGBTQ son or daughter. That's where the employee on the receiving end could look at that as harassment and violating of the anti-harassment and anti-discrimination policies that you have in place. So while it starts off as the political expression, it then crosses that line to the person on the receiving end on how they're taking that information, how it was set to them, and things like that. All right, so let's talk about some commonly covered political activities. So the first one is prohibiting employees from campaigning for a candidate or political party during work hours. During work hours is your main defense. That needs to be in the policy if you're going to go down this route. During work hours, they don't get paid to campaign for a candidate at a political party, for a political party while they're working for you. That's not why they're getting paid. So you're allowed to restrict that. Another is prohibiting employees from using their position within the organization to coerce or pressure another staff member to support a political candidate. You can't be having managers and supervisors using their authority for this type of behavior. I'm going to guess the majority of the companies on the phone here, you have an anti-bullying policy, right? It has nothing to do with political speech directly or anything like that, but you can't be coercing or intimidating an employee at the workplace. That's what you're going to rely on when someone crosses that line. Another example of a covered political activity is prohibiting the use of organization assets in support of any political candidate or party. Again, it's your company. You get to decide that you're not going to be paying employees and using your own assets to support any type of political party or candidate. Another example is prohibiting employees from harassing coworkers for their political beliefs. Again, that's coming under possibly your anti-harassment policy, but definitely your anti-bullying. It's definitely going to come under the realms of that policy. Another example is prohibiting employees from engaging in any form of political activity on the organization's premises. Prohibiting the use of social media accounts affiliated with your company in any way to post political views or opinions. Again, you're not saying what you're doing outside the workplace is prohibited, but what you're doing on your working time at your organization, that's when you're prohibiting it. All right, so let's transfer to discussions of politics at work. Obviously, as we know, I've seen it personally on social media. I have seen it, happen with my employers that I work with many times, especially as Bev mentioned earlier on the beginning of this presentation, that discussion of politics can quickly escalate to an argument, right? If everyone got along and, voted for the same candidate, we wouldn't be in the world that we live in today. So obviously, those discussions at work can get heated. They can get heated on social media between coworkers. So what's important here to know is that you're going to always apply your applicable policies when this situation arises between the employees. So as I mentioned, you're going to be relying on, hey, employee, I'm not reprimanding you for your political beliefs. What I'm reprimanding you for is you violated the anti-harassment or discrimination policy. You violated the anti-bullying policy when you were intimidating, coercing your coworker on who they should be voting for when you had that discussion about politics. So making sure that you have a broad and clear anti-discrimination and anti-retaliation policy is going to help employees understand that there are different statements that are prohibited in the workplace. Again, giving them that roadmap that says that kind of conversation and conduct is going to be prohibited. So again, that's where it all comes down to, and it's really important. I can't say it enough. The work environment has to be a place of mutual respect. You have to remind employees that, you know, I was giving, you know, training the other day, and, you know, many of the employees, including yourselves, you're at work more than you're at home, okay? And so you're working with people where it can get, that you're treating like family, you're with each other all day long, tensions can be there. You know, you just need to remind employees, you need to treat people with respect. I don't care if it's talking about making the widgets or if it's because you're talking about politics while you're working on the line. You still need to treat each other with respect, even if they have a difference of opinion, and learn to listen to one another. And you need to tell the employees you can't be letting any of these type of discussions regarding politics, religion, things like that to distract you from your job. You can't, because I'm here, I'm paying you to be here to make those widgets. So if you can't listen, you should have nothing to say. So if they don't want to be respectful, they don't want to have, you know, productive conversations, then you can't have them, right? And so, you know, just again, encouraging employees that, you know, you may disagree with someone, but that doesn't mean you have to escalate it into an argument. You can still be cooperative. You can still be courteous to one another during these conversations. You know, go further. You know, you want to prevent illegal harassment. And when people cross that line during this discussion, that's exactly what they're doing. So add to your policy that insists mutual respect environment in the workplace. You know, add, you know, that language that's harassing or negatively impacts working relationships will not be tolerated. Guess what? You're the employer. There's nothing illegal about doing that. You can add that to the policy. So when a political debate turns ugly, you have that language to rely on in your policy to say, this is why I am reprimanding you. Could lead to someone's termination eventually, okay? So now I'm going to turn it over to Bev so that she can get into more of the nitty-gritty on the type of activity.
Thanks, Heather. You know, that reminds me, I had an exchange with my 13-year-old daughter last night who I said to her, you know, I'm working on this presentation. We're talking about, you know, race, politics, religion in the workplace. And she said, well, what about it? And I said, well, employers really have to figure out what to do and how to handle, let's say, if somebody shows up at work with a Black Lives Matter mask. And being a 13-year-old, she says to me, what's the big deal? I don't get it. What's the big deal? She should be able to wear that mask, blah, 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 blah. And I said to her, well, what about the company policy that nobody can wear slogans and political statements and whatnot at the workplace? And she says, oh, well, you didn't tell me about the policy. I mean, so it just really kind of drives home, I think, what Heather is really trying to express there. And in that line, I'll continue with that. So, all right, now you're saying, all right, Bev, great. Heather, great. We have some excellent workplace policies in place. So now what? So now we need to look at the type of activity we're dealing with and whether or not there is, in fact, a company policy that applies and whether or not we're applying it consistently, because those of us who deal with claims related to discrimination, retaliation, and whatnot, we all know about the mighty power of the comparables, right? So if there are comparables, others who have been disciplined for similar activity under the same policy, boy, doesn't it really get us much further. This is much like the example I was talking about earlier when we said we had another employee who was disciplined under a policy for running through the workplace with his MAGA flag back and forth at the office, right? And so we'd want to be able to look at that before issuing any sort of discipline under these policies. Now, of course, the final evaluation is going to be the ultimate letter of the law, whether or not that employee's activity is going to be protected by any of the specific federal or state laws that we discussed earlier. So let's move on to the next slide, please. Religious speech. You know, we just talked about this, and I guess we're really trying to bring it home, but we all know that employers have an obligation under Title VII and the various state human rights statutes to prevent discrimination and harassment, and to take action when we have employees who are being targeted based on protected traits. Now, employers have to ensure that when they handle these matters, they're consistent. And in the religious speech context, for example, I'm talking about how can you allow a display of quotes from the Bible if you're going to prohibit quotes from the Quran. So that even, of course, the EEOC has recognized that an employee who's going to display a religious object in a private office is not going to create the sort of undue hardship or difficulty that we're thinking of where it's in other employees' faces, right? But if we're talking in contrast about somebody who is handing out leaflets, who is in the middle of the office space trying to teach Bible scripture or something of the like, that potentially disrupts the workplace, and even the EEOC understands that creates a hardship on the employer. So the bottom line is you should be able to point to an anti-harassment policy, right? You should be able to point to your code of conduct, which should allow you to restrict employees from harassing their coworkers regarding their religious beliefs if those views are pervasive and unwelcome. No surprise there, but I did want to specifically discuss religious speech. Next slide, please. When it comes to political speech, certainly employers, as we've been discussing, have the discretion to ensure that their work policies and expectations are being met. So even in these states where there are laws protecting political speech or conduct, an employer can discipline or discharge an employee for legitimate business-related reasons. For example, let's say you have a frontline customer service operation as part of your business. You observe one of your employees start to engage in a heated discussion with a customer who is wearing, a Me Too hat, right? And if the employee is not meeting company expectations, okay, in effect, the customer service rep has not serviced the customer, but is instead engaging in this debate, and is even causing other customers longer wait time, you as the employer certainly have a legitimate business reason to stop the conduct and even discipline that employee. So that if your neutral work expectations are set forth in a policy, you have something to rely on to stop this sort of political speech or conduct. Next slide, please. Generally, when we're talking about campaigning at work, employers can require employees to refrain from activities such as either campaigning on their own behalf, that of another candidate, or even passing out political literature. Again, this is with regard to work hours. And you would be relying on what you hopefully have in place, which would be a non-solicitation policy. These are policies that generally prohibit employees from being able to promote or solicit support for any sort of cause, whether it's political or personal even to an extent. So yes, even Girl Scout cookies would have, selling of Girl Scout cookies would have to be prohibited. I think employers have a hard time with that. I know that personally because I see it. When we recommend non-solicitation policies like this, I'm constantly hearing, so what are you saying? So we can't even ask for money for this? We can't even promote the lunch special for the restaurant in the building anywhere? If we're going to be very strict about it, yes. And the reason being is because non-solicitation policies are only as effective as they are consistently enforced. So that when you're in a position where you have to enforce it, as to people who are campaigning at work, soliciting support, political support for something, you can turn to it and have no issue being able to say, this is an existing established policy that is consistently enforced. Now, usually these non-solicitation policies are used to provide a basis for an employer to keep union organizers out and keep union supporters from encouraging union organization during work time. But again, these policies are very useful in situations where you are dealing with an employee who is campaigning on behalf of a political cause. Again, of course, we have to be mindful of the NLRA protections if that campaign or solicitation is aimed at discussing work terms and conditions with workers. In particular, that needs to be dissected further with respect to where it was happening and when it was happening. Next slide, please. Now, naturally, this leads into speech that is critical of the employer. Generally, as an employer, you can have a policy that says that employees are not supposed to use profanity or be malicious towards the company or its managers. However, that gets tricky, again, when we're in the zone of the National Labor Relations Act. Employees are usually given a bit more latitude if they are expressing objections to work terms and conditions of work. Now, in 2018, and here's really to highlight where that line is. In 2018, for example, the NLRB's Associate General Counsel issued a memo that stated that a group of employees who skipped work to attend a rally called A Day Without Immigrants, that they were protected under the NLRA because they had previously complained to their employer about mistreatment, and their work complaints were linked with the protest. So in short, these workers were protected because their strike was aimed at bringing attention to grievances specific to their workplace. So that would be the key. And now contrast that with Colin Kaepernick, for example, who engaged in this political conduct protesting police brutality in the midst of his work time at the NFL. That was not protected activity because it was not connected to his work terms and conditions, not protected under the NLRA. Now, of course, employees may have other protections, as we've talked about, including under Title VII. Let's say you have an employee who is engaged in speech or conduct that specifically criticizes her employer for its hiring and promotion practices. This is like the woman who was wearing the shirt. Hey, company, insert name, right? Why do you pay him more than me? She not only likely is protected under the National Labor Relations Act, she's probably protected under Title VII as well, which would prohibit an employer from retaliating against her for opposing an unlawful employment practice. Right? No 100% guarantee that that employee is going to win on that claim, but I can tell you it is certainly colorable. Next slide, please. So just to bring that home again, too, can an employer ask employees to stop discussing a wage increase ballot measure? Right? Fight for 15. Can the employer stop them from discussing it? I think it really depends on whether or not that ballot measure, that wage increase, is going to affect the employees who are talking about it. If it does, then certainly I think there's an argument that it would trigger NLRA rights because it relates, again, specific to their workplace terms and conditions. So it's a constant, fine evaluation of what all the facts are when you're trying to decide whether or not you're going to take action based on one of your policies. Next slide, please. Social media policies. We talked about this. Certainly, and Heather was giving examples of this where, she's seen these comments by employees on their own time, posting things on social media and it quickly escalating to a different level. The question the issue I'm raising here now, though, is employers really need to be careful about assessing that speech if they happen to learn about it. We don't know. I mean, there are employees who share, who are friends, I guess is the term, on Facebook with some of their employees, some other employees, and then there are, instances where employees will volunteer information regarding what is seen on social media posts. So, for example, if an employee complains on Facebook or on Twitter that the company is cheap because it pays substandard wages or allows a hostile work environment to exist in the workplace, that may be a violation of your non-disparagement language, right? Going back to malice and there may even be profanity directed towards the company, but it is also possible that that speech is very much protected. On a practical note, if employers are trying to determine whether or not blogs or social media posts violate company policies, we really have to look at it again on, what are the existing policies and what are the legitimate business reasons for involving yourself, the company, in this sort of activity. Does the expression violate the no harassment policy? Does it disclose confidential information? That is a big one to be able to rely on. Does the speech implicate the NLRA? Was it done during work time? Can that be ascertained? Was it done on a work computer or work device? Can that information be ascertained? So on a case-by-case basis, the employer really needs to analyze whether the speech is protected and whether or not there are other implications raised. Next slide, please. So as we've discussed and as we've seen day by day, employees are quite vocal and passionate about topics such as Black Lives Matter, the Me Too movement, gun control, abortion, and other topics. And they try to express themselves wearing shirts, buttons, and now masks that reflect their position on these topics. But companies, again, have a legitimate business interest in promoting certain dress and grooming standards, especially in retail, especially in healthcare, where there's contact with customers and patients. Of course, that legitimate interest is not tied only to those businesses. It's really a matter of, again, consistency and whether or not the company wants to be sure to limit that sort of expression through dress and appearance for everybody, for every cause. Some federal and state laws could apply. Again, the NLRA is a potential here in particular because you have a lot of unions who are very politically active. The difficulty is these days with all of this activity, you need to be very careful with how you respond. For example, if you have an employee who maybe a non-union workplace, but somebody is wearing now a union button and it's a union workplace. You have somebody wearing a union button, which they would likely be allowed to do, either under the contract or even under the National Labor Relations Act, but then that union button also expresses a political issue. If it expresses a position on a political issue, what do you do now, right? That becomes a much dicier issue. And if your policy is not broad enough and not consistently enforced, that's likely going to be a tougher one for the employer to get control of. Next slide, please. Use of company property, we've discussed this as well. But, it goes beyond the computers. It goes beyond using the email systems. It goes to bulletin boards. It goes to other areas within the company that employees may use to try to promote their political thoughts or political ideas. And the reality is, this is one of those policies, if you can point to it, it's pretty easy to apply. because they're not supposed to be using any company property for any resources for any of their political activities. Next slide, please. Attendance and absence is also another fairly straightforward one here. Those policies can be applied regardless of what information you may have regarding that employee's use of a day off, for example, for a political rally, or just not showing up to work. The idea is enforce the attendance policy and discipline accordingly like you always would, regardless of the reason. No reference to political activity should, of course, be noted or discussed with the employee, regardless of how you get the information. Just as a side note, some of the labor unions are politically involved again, and there could be language in those contracts that would protect those employees. Now, finally, political activities away from work, we have discussed somewhat. We talked about some of the state-specific laws that protect employee political activity away from work, but the analysis does not necessarily end with the existence of those laws. There should be discussion regarding the legitimate business reasons that justify trying to limit that off-duty political conduct, like harm to the company's reputation, disruption to the workplace and employee morale, potential legal liability because of the conduct, and then loss of business relationships. Without those legitimate business reasons, of course, employers can face all sorts of claims related to discrimination, violations of those various laws, and maybe even claims for invasion of privacy because how did you know what I was doing during my off time, right? But in short, the analysis involved in whether or not to discipline an employee for certain political conduct is really fact-intensive. Right? Anti-harassment and non-solicitation policies in particular have to be front and center at this time. Get it out there. Knee-jerk reactions are likely going to land an employer in hot water. And I'm going to turn this back over to Heather to discuss some hypotheticals and best practice to bring it home.
Thanks, Beth. All right, so we're going to end with, giving you some best practices that you can take with you when you're dealing with this when you go back to your desk. So, one of the best ways to reduce this risk for the company is training management. We've talked a lot about having your solid written policies in place, but really you need to train management on what's expected of them, how to handle it. Many of your management employees have worked their way up from the bottom. And they've worked their way up through the ranks because they've been great employees, but they've never been trained on how to deal with this. They haven't been trained how to deal with the argument between employees on political views. And so we're going to give you some additional, best practices. Is it a good idea to ban political discussions in the workplace? All right, well, employers in the private sector may generally, as we noted before, can put reasonable restrictions on political discussions during work time. Trying to restrict all political discussions is probably going to be impractical. You're not going to be able to really even be able to do that, and it might hurt your employee morale. It might have a negative effect on employees when you're saying, you can't talk about this at all. So instead, we recommend considering monitoring the issue. And if these types of discussions in your workplace, because every workplace is different, when they become disruptive, they interfere with work performance or potentially, violating the non-discrimination laws or non-harassment laws, then you can respond in accordance with your company's written policies and practices. When monitoring employees' conduct, you want to treat all the employees consistently regardless of their political views. So just make sure that you're consistently using these policies, but instead of just saying, nope, zero discussion, monitor it. Maybe you have a respectful workforce and they can talk about it and have discussions and it's not going to interfere with their work and it's not going to rise to the level of anti-harassment or discrimination or bullying or something like that. Then you're okay. But if it does get to that level, then you've got those policies in place. Again, your management, they play such a critical role. They're there on the floor. They're there at the day-to-day. Creating this respectful culture, it's got to come from the top. It's got to come from the top. If the top is not doing it, then the bottom is not going to be doing it either. They're going to say, well, if you don't have to behave this way, why do we? So you just want to make sure that your managers are setting by, an example. And again, know your workforce. If you have a workforce that includes immigrants, understand that issues on the border wall and immigration policies are going to be a sensitive topic. That's going to hit some trigger buttons, okay? And you need to be, and recognize that. Respect the diversity of opinions. That's the biggest thing here. You have to understand, which I try and tell my friends on Facebook, you got to respect each other. Just because someone has a different view, it doesn't matter. My dad always taught me it's called a secret ballot for a reason. But now today with social media, everybody wants to share, and now that's crept into the workforce. So you have to understand that I can still be friends with you. I can still be your coworker, even though you have a difference of opinion on the politics. Teach employees and your managers that they have to value what everyone brings to the organization. But if behavior does not follow the company policies, there's going to be accountability, and the managers are the ones who are going to be holding the employees accountable. And again, make sure that your managers are properly trained. If they don't understand what the policies are to begin with and how to manage them, it's just going to be chaos, and you're going to get a manager who has good intentions of following the policy, but they're going to step on NLRA rights or something like that, or workplace privacy or something like that, and without even knowing it, and not even having bad intentions. As always, stick to the policies. Have that clear policy. That's the best way to give the employees the playbook. It's the best way for the employers to control the politics in the workplace. This is why you're on this webinar, is to learn how to do it. It's got to have your clear policies. You can discipline or even discharge an employee for violating your workplace policies, so long as, of course, the policy is applied consistently to all employees. In most cases, employers should reserve discipline or discharge in instances where the employee's conduct interferes with his or her work activities or creates a disruption in the workplace. You rely on that, you're golden, okay? Enforce what policies the company already has in place. You got to enforce them. If you're allowing people to slide by and you're not enforcing them, they're not any good than the paper they're written on. Again, enforce them equally to everyone in the workplace. Once you start enforcing them unequally, that's when people go find a lawyer and they're suing the company because they're saying you're only enforcing the policy as to us and we're in this different protected class. Murphy's Law, it's going to happen. Again, make sure, Bev can't stress it enough, to make sure your policies are all in compliance with the NLRB and any state law that may apply. And have I mentioned, make sure your managers are trained. A lot of times, again, where I get the calls is because management didn't know what to do and they acted not consistently or improperly or in foul of the NLRA or something like that because they weren't trained. Had they been trained with the proper tools and guidance, they would know. So I'm going to end quickly on a couple hypotheticals. You've got an employee who wears a candidate's campaign button in the office and a coworker asks her to remove it because she thinks political beliefs should be kept out of the workplace. What's the response? Well, we recommend HR should first determine whether political beliefs, affiliation, or activity are a protected category in the state or municipality where your business operates. If not, then a company can set its own policy, but must be consistent in applying it. If buttons and stickers are allowed, HR should remind employees to just be tolerant and civil. So again, you got to be consistent on all spectrums here. Second hypothetical. An employee walking home from work sees a group of abortion protesters and recognizes a colleague in the group. The next day, she tells several coworkers what she saw, which prompts the protester to complain to HR. How do you respond with this? Well, the protester is free to engage in this activity outside of work. They're allowed to do it. And the employee walking home is also free to discuss it with their colleagues. So HR here should monitor the situation and see if it leads to any harassment or inappropriate commentary or bullying. You know, again, does it cross that line? Monitor it. You know, and then HR should also make sure there's no related conversation at work which involves religion, gender, pregnancy, or any other legally protected categories. Again, watch for it and monitor it to cross that line. When it crosses that line, that's when we need to nip it in the bud. So again, you're going to be getting, I'm going to go through them a little bit quickly because we're running out of time, but I want you to have these, and you're going to be getting these slides with our thank you email that's going to be coming out this week. So again, we've talked about it. Establish workplace policies, hold training with your organization. You don't need to just train your managers, train the employees. If you have lunch and learns or pre-shift meetings or whatever it is, go ahead and dedicate one of those meetings to what the company expects. What is the policy? Include that training on difference of opinion and what the harassment of another employee is. Again, management should be trained to refrain from making political statements in person or on social media, especially when they're friends with their subordinate employees. Train your management on how to diffuse. You need to learn how to diffuse these situations when they begin in the workplace so they don't escalate, so they don't lead to reprimands or discharges of employment. You want to limit or ban the visual displays in the office, such as posters, bumper stickers, etc. And if you hear a political conversation taking place, be the first to comment on it and reinforce a neutral environment. Simply say, I hear you. I hear that you are discussing politics, and that's okay. I just want to remind you to keep it tolerant and respectful. The key, again, is to keep your observation neutral, so you're not singling out certain political views or enforcing a policy from one perspective, or you crossing the line into harassment or discrimination. Again, keeping it neutral. Again, you're going to apply a neutrally enforced policy that restricts the solicitation only during work hours. This doesn't include your breaks or rest breaks. Okay, so you're allowed to be able to do that. It's a good idea to send out this reminder to employees about your policy right before election day, or before election day is coming, or when there's political boosts on certain topics. If an employer prohibits wearing political buttons or posting political posters, the company should be certain that that prohibition is followed absolutely. You can't be posting about Girl Scout cookies. You can't be posting about your church. Okay, you've got to keep it consistent. Employers, you can also ban political slogan buttons or t-shirts as part of your dress code policy, particularly for employees who come into contact with clients or customers. Again, you're having that policy related to that and not necessarily to the political speech. But again, the ban must be uniformly applied. If anyone, including the company president, wears a political election button, the ban loses its force, and an employee disciplined for violating the policy may have a claim for wrongful discipline or discharge, or even coercion under state law, because you're not applying it consistently. Keep in mind that any prohibition on buttons may not extend to union buttons worn during a union organization or election, because this, of course, is protected under the NLRA. So you got to be careful about that when you're doing that. So here is my information and Bev's information. You have our email. You have our phone numbers. I know we're running out of time to get to the questions, but we're going to respond to those because we have your emails. But if you want to reach out to us personally, please don't hesitate. We hope that we've given you the information that you need, but are happy to discuss with any follow-up questions that you may have. And we want to thank you for being on this webinar.